Got a question here asking if a landlord could put in a term in the lease that forbids a tenant from flushing the flushable baby wipes or other types of products down the toilet, and if the landlord could charge them for those baby wipes if they're flushed. Hi, my name is Rob Wells. I'm the Landlord Warrior on TikTok and YouTube. Please feel free to like, share, subscribe to our videos. Now, this is kind of common question we get, and I do have landlords that have terms in their lease agreements that do prohibit, a tenant from flushing other items down besides, normal toilet paper. Okay, a landlord could have a term in their lease that prohibits, flushable wipes, baby wipes, feminine products, etc., from being flushed down the toilet, and if the tenant does do that and it causes a clog and the landlord has to clear the clog, that the tenant is responsible for paying that cost of clearing the line out. That those are actually permissible terms in many circumstances here. Probably one of the issues I would probably be prepared to show is it's easy when you have a single family home and you have like records that, hey, listen, it's 1 unit per sewer lateral, and if things end up in the lateral that shouldn't be, such as the flushable wipes, quote unquote, or feminine products, that type of deal, and the tenant flushes them, the landlord's going to have the burden to show that the tenant has done such behavior and that there's a term that prohibits that in the lease agreement. It's also a good idea too to have a term of reimbursement too. So if the tenant does that and the landlord has to call someone out to clear the line, like a plumber, the landlord could submit a bill to the tenant, and if they don't fix that bill and continue to flush down the wipes, that type of deal, 3-day notices to perform, lease covenants, that type of deal for breaching terms of the lease could be issued to the tenant. Okay, some practical tips. Probably if you're going to have this type of deal in the lease agreement, the landlord should probably have records that, the lateral has been cleared, that type of deal. Particularly, if it's been a number of years, that type of deal where the lateral hasn't been cleared, because one of the things that the landlord's going to have to show is the tenant's actually flushing the stuff down the toilet. Might be obvious if it's getting stuck within the toilet itself and that so forth, but if it's a clog down in the lateral, so to speak, roots and other vegetation can grow in a lateral, and it could cause clogs and so forth backed up. I had trees in my yard that get in the lateral sometimes, so the issue might be preventative maintenance versus an intentional clog. But it's a good idea. With nowadays, plumbers have the cameras that can go through the lines, and you can exactly see what's being thrown down there, so to speak. It's easy to show that the tenant may be flushing things down the toilet. A little bit harder if you're in a common like development, like a condo complex or apartments with shared laterals. Was one of the complaints from one of the HOA presidents. They would always tell me about, because the units shared a lateral, it's hard to prove who flushed down what. So those are some considerations. You could have those terms in your lease, and they can be enforced in court as well. So landlords, if you have a situation where your tenant's not doing what they're supposed to be doing, such as flushing down wipes and things that are clogging up the lines and so forth, and you need help, feel free to reach out. We might be able to help out. Put your comments, questions down below. Until next time, folks, I'll talk to you then. Thanks.